Welcome, and thank you for joining us. Please note that this AI-generated podcast is intended solely for general learning and educational purposes. While we strive to ensure accuracy, the AI may occasionally produce errors or incomplete information. We strongly encourage you to consult qualified professionals and conduct your own due diligence before making any legal, financial, or business decisions based on the content presented here. Also, if you find this content valuable, we kindly request you to like the video, subscribe to the channel, and activate the notification bell to receive updates on future episodes. Let's begin.
Welcome back to The Deep Dive. Today, we're jumping straight into some pretty intense corporate litigation. We're talking intellectual property, millions of dollars, but it all boils down to snack food and grammar.
That's right. A huge patent fight where, believe it or not, the difference between a successful product and, well, a disaster hinged on just two little letters. The word "to."
It sounds almost trivial, but the stakes were massive. So our mission today is to really break down this specific Federal Circuit case, Chef America, Inc. v. Lamb-Weston, Inc. We want to give you a clear, structured look at the judgment, answer all those core legal questions,
And explain exactly why, in the world of patent law, getting the language precisely right can sometimes matter more than what you actually intended the invention to do. It's a fascinating deep dive.
Absolutely. The hook here is pretty wild. A patent meant to create a flaky, crispy snack, but interpreted in a way that allegedly resulted in a charcoal briquette. Let's start with the basics. Case identification, who, where, when.
Okay, so the case is Chef America, INC, Plaintiff Appellant, v. Lamb-Weston, INC, Defendant Eppley. The case number is 031279.
And the court.
This decision we're focusing on is from the United States Court of Appeals for the Federal Circuit. The judgment date was February 20, 2004.
Right. The Federal Circuit handles all patent appeals. But this case didn't start there, did it? It came up from a lower court.
Exactly. It was appealed from the United States District Court for the District of Colorado. The judge there was Judge Edward W. Nottingham.
And who was on the panel at the Federal Circuit?
The panel deciding the appeal included Circuit Judge Rader, Senior Circuit Judge Friedman, and Circuit Judge Schall. The opinion itself was written by Senior Judge Friedman.
Okay, and we should probably mention the lawyers involved. Gives a sense of the scale here.
Definitely. Chef America was represented by Finnegan, Henderson, Faribault, Garrett & Dunner, a major IP firm, and Lamb-Weston had Bingham McCutcheon LLP. So, these weren't small players. This was a significant, well-funded battle over very specific technical language.
Big guns for a battle over two. Okay, let's get into the substance. What was this patent, the 290 patent, all about? What was Chef America trying to protect?
So the 290 patent belonged to Chef America, and it covered a process for making a dough product. The key selling point was that when you finally cooked it, maybe baking, maybe microwaving it would have a light, flaky, crispy texture.
Which was apparently a big deal, avoiding the usual problem.
Yeah, exactly. The patent aimed to solve that common issue where frozen or convenience dough products end up kind of leathery or tough or just soggy after cooking. They wanted crispy.
And how did the patented process supposedly achieve this crispiness?
Well, the process involved a couple of steps: applying shortening flakes to the dough, adding a light batter coating, and then, this is the crucial part, a step involving quickly heating the batter-coated dough.
Why is the quick heat?
The idea was that this quick heating would form tiny air cells, or pinholes, inside the dough structure. These pinholes were supposed to let heat penetrate quickly during the final cooking, ensuring it got hot and brown fast, leading to that desired crispy texture.
Makes sense. So, Chef America has this patent, and they believe Lamb-Weston is using their process.
That's the core of the lawsuit. Chef America sued Lamb-Weston, Inc., claiming infringement of this 290 patent.
Okay, so the lawsuit starts in the district court. What happened there? You mentioned a Markman hearing earlier.
Right, the Markman hearing is absolutely pivotal in patent cases. Before you can even get to whether someone infringed, the judge has to formally decide what the words in the patent claim actually mean. It's called claim construction.
So the definition of the words comes first.
Precisely. And in this case, following that Markman hearing, Judge Nottingham, the district court, actually granted partial summary judgment to Lamb-Weston, the defendant.
Why? What was the interpretation?
Because the court construed the critical claim language, the part about heating, to mean that the dough itself had to be heated up into the specified temperature range, which was quite high.
Not the oven air, but the actual dough product.
Exactly. The dough itself had to reach, I think it was 400 to 850 degrees Fahrenheit.
Wow. Okay, I can see where this is going. So Lamb-Weston argued they didn't do that.
Correct. Lamb-Weston showed they didn't heat their dough products to that internal temperature. And once the court locked in that definition of the claim, Chef America's infringement case basically evaporated at the district court level.
So summary judgment of non-infringement was granted, and Chef America had no choice but to appeal to the Federal Circuit. Their entire patent's value now rested on getting that definition overturned.
That sets the stage perfectly.
Yeah.
The appeal landed at the Federal Circuit with basically one single, very narrow legal issue to resolve.
Which was?
The precise meaning of that phrase in Independent Claim 1. Heating the resulting batter-coated dough to a temperature in the range of about 400 degrees Fahrenheit to 850 degrees Fahrenheit.
So, boiling it right down, does heating to a temperature mean the dough reaches that temperature, or does it mean the dough is heated in an environment like an oven set at that temperature?
That's the million-dollar or perhaps multi-million-dollar question.
Let's unpack the arguments. What was Chef America, the patent holder, arguing on appeal?
Chef America argued strongly that to should be interpreted functionally, essentially meaning at. They were saying, look, it refers to the ambient temperature of the oven where the heating happens.
And their justification for reading to as at was practical reality.
Pretty much. Their core argument was grounded in common sense baking. They said if you interpret this literally heating of the dough itself to 400 degrees, let alone 850 degrees Fahrenheit, the result is utterly nonsensical.
Nonsensical how?
It would incinerate the product. Their own expert, a Mr. Lehman, who was their director of baking assurance, testified that heating the dough itself to those temperatures would leave you with something burned to a crisp, basically a charcoal briquet.
So, the argument was no one skilled in baking would ever read the claim literally, because it describes a process guaranteed to destroy the very product it's trying to create. It contradicts the whole point of the patent making something light and crispy.
Exactly. They argued the only sensible reading, the one that makes the patent actually work, is to understand to as meaning the oven temperature, at.
Okay, that sounds like a compelling practical argument. What was Lamb-Weston's counter? How did they defend the literal reading?
Lamb-Weston, whose position was upheld by the district court, took a very strict textualist approach. They argued, essentially, the claim language is perfectly clear. It's unambiguous. It says, heat the dough to a temperature.
It means what it says, even if the result is weird.
Precisely. Their point was that courts are not supposed to rewrite patent claims. The language is what the patentee chose. If the plain, ordinary meaning of the words leads to an odd or even inoperable result, that's the patentee's problem, not the court's job to fix by changing the meaning of simple English words.
That's a stark contrast. Functional reality versus strict interpretation of the text. So the Federal Circuit hears both sides. What did they decide? How did they rule on the meaning of to?
They sided with Lamb-Weston and the district court. The Federal Circuit affirmed the judgment of non-infringement.
Wow, so they stuck with the literal interpretation.
They did. They held that the claim unambiguously required the dough itself to be heated up into that 400 degrees Fair to 850 degrees Fair. Chef America lost. The word to meant to.
Even acknowledging that this interpretation led to the charcoal briquette outcome, that seems counterintuitive, almost like ignoring the inventor's clear intent just because of one word. What was the court's detailed reasoning for such a strict stance?
It was very methodical. First, they leaned heavily on the ordinary meaning principle. Judge Friedman wrote that the claim used ordinary, simple English words whose meaning is clear and unquestionable.
Just plain English.
Right. In everyday language, if you say you're heating something to a certain temperature, it means that thing is reaching that temperature. The claim specified heating the dough. Therefore, the ordinary meaning is that the dough reaches the temperature.
But what about the argument that this ordinary meaning leads to an absurd, unusable result? Didn't that carry any weight?
This is probably the most critical part of the ruling. The principle of no rewriting allowed. The court was very firm on this. They cited their own precedents, stating they have repeatedly and consistently recognized that courts may not redraft claims.
Even to fix an obvious mistake or make the invention work.
Even then, the court explicitly said they can't rewrite claims to make them operable or to sustain their validity.
Yeah.
They acknowledged that the result might seem nonsensical, maybe even regrettable for the patentee, but that doesn't give the judiciary license to step in and change the claim language the patentee chose.
So the burden is entirely on the inventor to get the words right in the first place.
Entirely. The court basically says, we interpret the claims as written. If that means the claim describes something useless or impossible, so be it. That's a drafting failure, not a reason for us to become editors.
Was there anything else in their reasoning?
Yes, a very important point about the prosecution history. This refers to the back and forth between the inventor and the patent office when the patent was being applied for.
How did that play into it?
The court looked at how the claim evolved. It noted that the word "at," the word Chef America wanted the court to adopt, was actually used in other parts of the patent document, like in the examples describing the process working.
So the inventors knew the word at and used it elsewhere.
Yes. But when they finalized the language for the crucial independent claim 1, they specifically chose the word "to," which appeared in the specification and an original broader claim. The court saw this as a conscious choice.
Ah, so the court reasoned that if they could have used at and did elsewhere, but chose to for the main claim, they couldn't now argue that to secretly meant at. They were stuck with their choice.
That's exactly the inference. It heavily suggested they didn't intend to mean "at" in that specific claim context, or at least they failed to make that clear. It was a self-inflicted wound during drafting.
A fatal drafting error, it sounds like. And what about the expert testimony, Mr. Lehman saying any baker would know it meant oven temperature?
The court addressed that too. They essentially rejected it, finding that the expert's testimony wasn't really about establishing that "to" had some special technical meaning within the baking industry that differed from plain English.
What was it based on then?
It seemed primarily based on avoiding the nonsensical result. He was saying we have to read it as "at" because reading it as "to" makes no sense. But the court's rule is clear. You can't use expert testimony, extrinsic evidence, to contradict the plain, unambiguous meaning of the claim language itself. If the words are clear, they control, regardless of expert opinion on practicality.
So the plain language trumped the practical baking knowledge. Did the court cite specific prior cases to back up this strict approach? Any key precedents?
Oh, yes. They leaned on established Federal Circuit case law. Cases like Process Control Corp. v. Hydroclane Corp. and Ryan v. Casio, Inc. were mentioned.
And what's the general principle from those cases?
The core idea reinforced by those precedents is that when patent claim language is susceptible to only one reasonable construction, based on its plain meaning, the court must adopt that construction, full stop, even if that construction renders the claim invalid or, as in this case, leads to a finding of non-infringement, because the described process is absurd. The integrity of the claim language, as written, is paramount.
Clarity above all else, even if it seems to defy logic sometimes. Okay, one quick check. Was the decision unanimous? Did any of the judges disagree, maybe write a dissent or a separate concurrence?
Good question. Based on the source material, no. The opinion was delivered by Judge Friedman for a unanimous panel. There's no indication of any dissenting or concurring opinions. They were all aligned on this strict interpretation.
All right, so pulling back from the specifics, what's the broader legal significance of this Chef America ruling? Why does this case still matter for patent lawyers and inventors today?
It's a really powerful reminder, maybe one of the starkest, of a fundamental patent law principle. The patentee is the master of their claim language. But with that power comes immense responsibility. Chef America hammers home that clarity and precision in claim drafting aren't just nice-to-haves, they are absolutely critical.
Because the courts won't save you from your own bad wording.
Exactly. If your claim, read plainly, describes something that doesn't work or isn't what you intended, the burden falls squarely on you, the patentee. The court won't step in to fix ambiguous or poorly drafted claims to align with what you meant to invent. It's cited often when there's that clash between the literal words and the alleged functional intent.
Okay, let's distill this down for everyone listening. If you had to pick the single most important takeaway from this whole saga, what would it be?
I think the absolute key takeaway is this. In patent law, words have immense power, and even tiny words matter immensely. A seemingly minor drafting error, like using "to" when perhaps "at" was intended, cannot be excused or corrected by a court if the chosen language itself is clear and unambiguous, even if that leads to a commercially disastrous or technically nonsensical outcome.
The specificity is absolute. Functional intent doesn't override clear text.
That's the lesson. Your patent protects what the words say it protects, not necessarily what you hoped it would protect.
So what does this all mean? Chef America set out to patent a brilliant process for crispy snacks. But through the quirks of legal interpretation, and crucially their own word choice, they ended up with a Federal Circuit decision confirming their patent technically covered, well, making charcoal.
It's a sobering thought, isn't it? It really highlights the potential commercial cost, millions in litigation, potentially lost market opportunities stemming from what might seem like a tiny linguistic slip-up during the patent application process.
A costly preposition.
Indeed. And the provocative thought to leave with is this. It underscores how vital it is during patent drafting to not just think about describing your invention, but to actively anticipate how others might attack the language. You almost need to stress test your own claims, asking, could someone argue this leads to a nonsensical result? And ensuring your wording prevents that. Precision isn't just about accuracy, it's about defense.
A really crucial point. It makes you wonder what other seemingly insignificant words buried in contracts or patents hold that kind of destructive or protective power. Thanks for breaking that down for us.
My pleasure. It's a case that really sticks with you.
Absolutely. Thank you for joining us on the Deep Dive.